Bliss, what it do, what it do. Yo, 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 what's good, beautiful people? How y'all doing? How y'all doing? How y'all doing? Dun, 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 dun. All right, we're gonna have us a good one tonight, man. I hope y'all ready for this one tonight. What's up, Mike? Check me out on all of them. Make sure we good. Well, we definitely about to have a good one tonight. I hope y'all ready though, for sure. Beautiful night, beautiful night. We're gonna kick it, man. Gonna have us a little fun. LIP. What's up, Cam? What's up, Mike? I appreciate you. Let me know we good. We good and rolling, good and rolling, rolling, rolling. Straight up. About to kick this thing off for y'all, man. We about to kick it off for y'all, man. I don't like how they don't show me who all up in here, though. Don't do that no more. Sometimes they do. We sound good, good. All right, say less, man. Say less. It's gonna be a beautiful day, man. Beautiful night, beautiful night. Hey, man, tell me if you can hear this. Oh. Oh. Ow. Swag. Yeah. Stay loyal, my nigga. We about to have us a good time tonight.
If you love me, would you cry for me? Yeah. If you love me, would you die for me? Yeah. Say you love me and you saying it's forever. Some people they done told me it's forever. Yeah, but they ain't right. Hey, they ain't right. They ain't
Why y'all
right,
come
they
on
ain't
up in here
right.
tonight?
Hey, they ain't right. No, they ain't right. Hey, they ain't right. They ain't right. They ain't right.
Yup. We up in here tonight now. I hope y'all ready now.
I know some me right off in my face.
You know what I'm saying?
Told me it's forever.
Cause we up in here.
I had some was they really down to ride.
You feel me?
Some situations happen, then they
Cause we not turning around no more. We here. Hope y'all ready. Alright, let me know. I tried to hit you up early, bro. It's all good though. Let's go. They hating. But we gonna keep it moving, bro. We ain't worried about it.
I'm not a real nigga, I'm just more in the streets. You're not a real nigga, you just a bitch in the street.
Hey, you hear me though? Why you trying to take my heart from me? You hear me? So tell me what you're here for. It's really up, man. It's really up.
If you love me, would you cry for me? Yeah. If you love me,
We
would
really
you
up,
cry
man.
for me? Yeah. Say you love me and you saying this forever.
Tonight we talking about creditors.
Yeah, but they ain't right. Hey, they ain't right.
Yeah, we're gonna talk about these creditors, man.
Hey, they ain't right. No, they ain't right. Hey, they ain't right. They ain't right. They ain't right. Hey, they ain't right.
Yup.
These niggas held out their hands. I even put some there. Yeah.
Did we not?
40 ain't right at your head, nigga. Let's play truth or dare. Yeah. Cause truth is, I should
Hey.
truth is, I should
We shouldn't even be nowhere near, you feel me?
Tell me if you would.
Cause they ain't right.
They ain't right. They ain't right. They ain't right.
Hey.
They ain't right.
Man, a dope song. Never got put out though, but hey. That song riding for life. Man, welcome everybody. Man, what is going on with you guys today? As I always say, it is a beautiful thing to have you here attending with me. As always, none of this would be going on without you. And I'm all about the reciprocation of energy with you guys. So appreciate you for your time and locking in with us. We're going to have a great casting for the night, and we're going to be speaking on how to handle these creditors and some of you guys that are actually dealing with these creditors in courts, things like that. How to keep your money from being garnished and stuff like that. So we're gonna give you a different few financial strategies and do's and don't do's and things of that nature. And we just give thanks to the Most High to be able to present this information to you, and just just to keep uplifting and go check us out on. We on YouTube, so if you're on YouTube, In God We Trust Academy, here on Facebook right now, you guys are logged in with me on Eric and Bay. But make sure you guys go follow In God We Trust Academy on Facebook as well, and on Twitch, and as well as on TikTok here with us. Make sure you lock in, subscribe with us as well, so we can continue to make this grow. Okay. Alrighty, so we're doing this for you guys to help you guys get a better understanding. I know some of you guys really want to see the screen when we're doing stuff, so we're gonna open up this opportunity for you. And how well this goes depends on how well you continue to share with others. And the way you do that is you just hit that share button. Continue to share. All right. So again, everything that you guys are gonna hear from this point on is for education and religious purposes only. Anybody seeking any form of legal advice, please do seek a legal advisor, as it is my religious duty to speak my religious truth and experiences with you guys, as that is what my whole entire life is. It is divine, and it is also divine in my own right, that my whole entire life has been given to God and to worship and to express that glorification to God on a daily basis, and fully protected by the First Amendment, which a lot of you do not understand, but we're going to get y'all caught up with this type of stuff, right? This is the main thing. So with that being said, man, if y'all with me, drop some ones. Let me know who up in here with me. Where y'all from? Let me know. Where y'all from? Drop some ones. Let's see what y'all got going on. Yes. So 369. East Texas in the house. Okay, East Texas. Los Angeles in the house. What's happening? Who else we got? Who else can I see over here, man? Let me see who else y'all got, man. Okay. Arizona. That's what's up, man. So we're getting a little love from everywhere today. Well, we report live to you guys from old Alabama, right? Cali, what's good? Cali in the house. Arkansas, next door neighbors. Yeah, man, it's beautiful though. Appreciate it, man. Appreciate all you guys that are tuning in from everywhere. All right, so let's do what we do, man. We got upcoming December the 7th, Private Administration Conference. It is a conference here in Huntsville, Alabama. The donation is in person for $250 and live stream for $200. We're going to be talking about private court settlements and things like that. Lawful money protection, easy to use financial strategies. And when we talk about private court settlement, it's based upon you doing a private administration to fully, even if they try to take you to court, that you are fully prepared and you've asked all the questions and things that you need to ask. In relations to, getting the debt validated and the things that you're going to need. And so what I'm going to show you today is going to kind of fall into that a little bit. So just to kind of give you an idea as well. So I hope you guys are ready and prepared for this. All right. All righty. So again, drop me some ones if you guys are ready. Drop me some ones and hit that share button, man. Show some love. Man. Absolutely. Show some love, because it is time for us to share some love with you guys, man. I hope y'all ready. I do not know how many people we have in here with us today, but we're going to be all right, though. Let's go. All right. So let's jump into this, man. All right, so today we're going to be speaking on creditor, their lawsuits, and their garnishments, right? So when a creditor sues to collect the debt, The goal is often to secure a court order that allows them to garnish the debtor's wages or bank accounts. And garnishment is a process where the creditor legally intercepts part of the debtor's income directly from their employer or financial institution. Well, I want y'all to think about that, man. If somebody does this to you, does this cause you harm? And first, you got to ask yourself, does your money, the money that you're working for, or your hard working income, I want you to ask yourself a question. When you're working for this money, right? You need to understand one thing. Your money is already spent, no matter what, whether it's groceries, bills, or whatever. So those things are already are entitled to go certain places. And what I mean by that, that sets up what you call a form of trust. See, a lot of you guys don't even understand that part because you already got a certain amount that has to go to gas. You already have a certain amount that has to go to tithing, right? And remember, your religion says that what? Everything should be given to God first, not the state. Not the state or anybody else that's considering trying to garnish your money. God get his first. So you have the right to express that. And by expressing that, well, guess who has the right to protect that? The courts do as well, because they cannot interfere with your religion. So they can't make a court order requesting that some money be removed and that they're able to take out taxations and all of this stuff first. And if you really want to stop all of this type of stuff, again, religion is the main key. First Amendment, you have the right and liberty to express and exercise your religion, right? Absolutely, absolutely. I hope you guys understand that. So the debtor has the right to respond to this legal action by challenging the creditor's claim and questioning the legitimacy of their right to collect. Ignoring a lawsuit can lead to a default judgment where the court automatically rules in the favor of the creditor, allowing garnishment to proceed without further challenge. So what you guys got to understand is this, right? Take this into consideration. Number one, you have to answer. Okay? You got to answer. And a lot of you guys don't want to answer, and you need to answer. Okay? You don't just need to run from this at all because it's going to allow them to literally, okay, take your money. But you need to be prepared, and I'm going to show you some things today that's going to help you prepare. But as I said to you earlier, your money already has a place to go. It's already entrusted to certain things. And these people should not be able to come in your life and start causing you harm, especially if they can't even validate the debt, which is another thing that we're going to speak on tonight, right? So you got to understand that part, right? Drop some ones if you're with me before we continue forward so I can know that you guys are with me, right? Drop them ones. Drop them ones. Because I need to know. I need to know. So now we need to understand with this, right? So when it comes to the lawsuit, there are certain things that we have to make sure that the creditor has in order to fully make a claim. All right. Number one, that the name has to be correct, right? So the lawsuit must target the correct individual with the exact legal name as the defendant. Misnaming introduces procedural errors that may allow for dismissal based on mistaken identity. Again, it has to be correct. Just the same as that if you file a UCC, you have to have the correct debtor's name. If anything is slightly wrong in it, then that's not that person, right? So, and they also have to have a standing and original documentation. So only the rightful holder of the original promissory note or debt agreement has standing to enforce the debt. If the creditor is a third party or debt buyer, they must present the original document as evidence of their legal right to collect. So a copy of the document alone is insufficient to establish standing. This protects debtors from fraudulent claims and ensure only legitimate creditors can enforce debt. So you guys got to understand this too. There cannot be a copy. A copy, that means like I can go take a copy with something that says pay to the order of me or for value received, etc. The way the banks transfer their instruments, right? Anybody can do that and show up to court and say you owe, right? as just somebody taking a formal copy, etc., and going to claim a debt against you. They need to be able to fully prove it, right? Because those things should be transferred. The instrument and the original note should be transferred to a creditor if they're going to be acting. If something was sold, so that's like if another creditor bought somebody else out and bought the company out, or whatever the case may be, that creditor should be transferred any and all assets, meaning financial assets. Those assets have to be transferred to the new creditor in order for them to even be saying that they are now the holder in due course to actually enforce the debt, right? That's something that you have to understand, right? All right. Can everybody hear me good? Some people said they're having a hard time hearing. Y'all can hear me? Y'all straight? Let me know y'all can hear me good. We good? Because some people say they can't hear. Can y'all hear? Oh, okay. Y'all should be able to hear me real loud and clear. Okay, so now, with that being said, right, there also has to be a chain of title. So when a debt has been transferred or sold, the creditor must show, okay, an unbroken chain of title from the original lender to the current holder, as I was saying earlier, right? So each transfer should be documented clearly, proving the debt's path from the initial lender to the current claimant. Mislinks, or unclear transfers may invalidate the creditor's claim, as it suggests ownership is not legitimate or verifiable, right? So also consideration, debt enforcement requires proof that the creditor extended values such as funds or to the debtor. If there's no documentation, all right, if there's no documentation of value exchange, there is no enforceable contract. Without consideration, the court may dismiss this claim as invalid. So I want y'all to understand that, right? So we need full debt validation here, right? So, and here's the thing. I was actually had a consultation with somebody, and they actually had an audit of their actual mortgage, right? And they had the expert to literally point out everything in red of all the wrong doings and fraudulent things that they were doing in the actual audit. So what y'all got to start doing is this, though. It's understanding this part, right? All you got to do is look in that audit and prove they don't have the note. If you can prove that the note is in a real estate investment trust, then they're not the holder in due course of it. They don't have the right to enforce it. So that's what y'all got to start seeing too. And once you start understanding that part, it's going to make everything very, very, very different for you. Because all you got to do is have evidence and proof. But the burden of proof still relies on them in certain different ways as well. But again, so let me continue forward. The authority of representation. So if the creditor is represented by an attorney, the attorney must have proper authority to act on their behalf. So without documented delegation of authority, the legal actions taken may lack legitimacy and potentially leading to dismissal. So again, the attorney needs to be fully approved by whatever company, by the board of trustees or whatever the case may be, in order to sue on behalf of the company. If they don't have that, then again, that recuses the attorney and also the actual case, because the attorney don't have the power to bring forth the case as well, right? So again, it all comes into authority, delegation of authority and power as well. So know that. Now, the third thing here is debt validation and proof of requirement. So debt validation is a process by which a creditor must prove the validity of the debt, and this includes a detailed accounting of the debt, amount, origin, and any interest or fees applied. So a debtor has the right to request validation within a certain period after receiving a notice from the creditor. So validating the debt involves obtaining a clear statement of the owned debt, documentation linking the debt to the debtor specifically, such as the original agreement, proof that the creditor owns the debt or has a legal right to collect on it, which means they have to come forward and show proof of the original note, as always. So creditors who cannot provide these details lack basis to enforce the debt, which can be grounds of dismissal of the case, and the step is crucial in challenging third-party debtors, right? All third-party debt buyers. Here's the number one question you can ask. So let's get to this. That's another thing. Okay, so check this out. If, let's say you go to the grocery store, and I'm gonna break this down to y'all so simple, so simple. I need y'all to look at just me. I don't need you to be doing nothing else. Look at just me. Listen, I'm gonna break this down to y'all so simple. Let's say you at the grocery store, and let's say you got about $400 worth of groceries, right? You just they scanned all of it. They tell you your total is $450. And let's say I pay the $450 and they give me a receipt. And I tell you, hey, you owe me $450 plus interest. I want you to think about that. Okay? So you got to look at it like, one, I don't have a contract with you. Two, that was a gift. Thank you. I really want y'all to start thinking about that. Because that's what's happening to you by third-party debt buyers. That's a gift, bro. I appreciate it. Thank you for paying for it. I don't owe a dime to nobody now. Thank you for being a surety. Because now they acted as a surety. But since they acted as a surety without permission, it's a gift. Drop some ones if you're with me. Drop some ones if you're with me. I don't think I understand that part. This is considered a gift. This is a gift, right? So you got to understand that part. That's what's happening to you while you're sitting there and you're like you're in the line, the grocery line, and somebody paid for your stuff, and now they come to you and say, like, hold up, bro, I didn't ask you to do that. But you did it. I appreciate it. Thank you. It's considered a gift. And we keep it pushing. Right? So understand that part. And I don't think people notice that. Okay? At all. Okay, so now watch this. If they can't produce it, then they're in the wrong anyway. So in debtor-creditor relationship, creditor are also subject to the claims of the debtor. This means that if a creditor attempts to collect without following legal procedures, the debtor can counter with claims of their own, such as unlawful debt collection, right? The debtor can counterclaim for damages if the creditor engaged in a harassment, failed to validate the debt, or violated debt collections, fraudulent or misleading practice if the creditor, has used deceptive tactics, inflated interest rates, or added unjustified fees. The debtor can file a counterclaim to offset these charges against the debt amount, and they can also do a set-off and recoupment, which means these legal tools allow the debtor to reduce the amount claimed by the creditor if there is proof of inflated charges or improper fees, which actually means it's a breach of contract, even if they want to consider that. So now, since there's a breach of contract, you can really just set it all off and receive all benefits as well. So, for example, if a creditor improperly increased the debt through unapproved fees, the debtor can use set off to decrease the amount owed, and which is all of it. You can set it all off because they're in breach of contract. So now you got the right to restitution. Just like if you do something, they're going to seek restitution based upon their fees and research fees, attorney fees, court fees, and all this extra stuff they're going to want you to pay for. So it's the same thing with you, right? You got to look at it from that standpoint. All right. So now, counterclaim, right? When facing a lawsuit, the debtor can file counterclaims based on the creditor's action. These can include claims of unfair debt collection practices, fraud, breach of contract, as I just said, violation of federal debt collections as well. Counterclaims shift the burden of the creditor to defend their conduct, potentially reducing or invalidating the debt claim. So in the midst of this, guys, you always want to protect your assets, and your assets is your money. All right, they are called it's financial assets. So you need to protect your finances. all of your money, protect it. And the only way to protect it is through trust. Okay. So that, and as I was saying to you guys earlier, like, remember, you go to work and you work for a specific reason. And the reason you're working is to take care of household and personal things as well, right? So it's already entrusted. That money can't be touched if you know that it's entrusted already. Just like I said, like some of the money that you have is already God is to get the first earning. So how is it that they're going to make you be and commit sin and that causes you harm, spiritual harm, right? Spiritual hardship. You got to understand that part too. That's a thing. That's really a thing. So let's say it causes you harm. What are you going to do? What are you going to do? And that is the question, because you are experiencing spiritual hardship. Now they're causing you to miss your increases on what God said he was going to give based on you tithing, right? Man, yeah, I think a lot of people really, really, really miss this type of stuff. So I just want you to know, man, shout out to King Biggs for subscribing to us on in YouTube, bro. Thank you, thank you. And God We Trust Academy. All right, so again, also look at it from this point, guys. All right. Look at it from this point. Okay. So you need to be able to place in your assets such as income and financial counsel to a trust and can protect these assets from personal creditor claims. And trust allow individuals to separate personal assets from direct ownership, meaning creditors may not access these assets directly. And that's a fact. Okay. So you can literally put in there that your church gets first earnings off 10%, right? So irrevocable trusts offer stronger asset protection that revocable trust cannot at the time. So, and in an irrevocable trust, the assets are legally owned by the trust itself and are out of reach for creditors pursuing claims against the debtor. The debtor has no direct control over the assets once transferred, making it difficult for creditors to attach them, right? Revocable trust still offers some level of protection, but because the debtor retains certain control over the asset, creditors may be able to claim against them in specific cases. So the best thing to do is just relinquish yourself from having all control as the actual individual, but still having control as the trustee and still having the right to receive things as the beneficiary. But you got to remember, anything that if you consider the legal fiction to touch as the beneficiary, then it's going to be able to consider to touch that. So you just want to keep it all within the trust anyway. And even the beneficiary has the right to benefit and use those things, but they still belong to the trust. I hope that makes sense to you guys and give you a better sense of direction in that, right? I hope it does. Okay, so let's move forward on this part, right? So now conditional acceptance and shifting the burden of proof. So conditional acceptance is a strategy where the debtor conditionally agrees to the creditor's claims on the condition that the creditor meets specific verification requirements. This technique requires the creditor to produce the original debt agreement or promissory note, also a full accounting of how the debt amount was calculated, evidence of each transfer of debt ownership, and documentation showing that the creditor extended credit or funds to the debtor. Meaning they got to show proof that show me how this caused you harm. One, because we need a contract. And if we don't got a contract, then like I said, this just like you giving me a gift. I appreciate it. I appreciate you paying for that for me. That was pretty nice of you. Thank you. That's about all you're going to get. Nobody asked you to do this. You didn't sign on this contract as a surety, so you did this out of your own goodwill. We surely do appreciate you, right? We surely do appreciate you, and I hope you guys understand that. I hope you guys understand that, right? So this approach puts the responsibility on the creditor to prove their case in detail. If they cannot meet the conditions, the debtor can argue, right? They can argue that the debt claim is unsubstantiated, right? So objecting to the garnishment. If the court has approved the garnishment, the debtor can still file an objection by presenting the evidence that the debt is improperly documented or that the creditor did not follow proper procedure as well. And some income types are legally exempt from garnishment, such as Social Security benefits, unemployment benefits, and retirement income. The debtor can claim exemptions to prevent garnishment of protected income as well, guys. And if you need to, there can be an appeal and a motion to actually quash. If the garnishment is already in effect, the debtor can appeal to move or quash, invalidate the garnishment order. Grounds for this can include lack of documentation, failure to validate debt, or procedural violations. Or you could also do things like injunctions, which is other equitable procedures, because if you can't receive something by statutory law, then you do have the right to receive it in equity, which is where injunctions and forms of abatements and stuff like that comes into play as well. So debtors have substantial right when it comes to defending against creditor lawsuits and garnishments by requiring the creditor to validate their claims, proving the debt's authenticity, and protecting certain assets. The debtor can often reduce or dismiss the claim. So keeping detailed records and staying proactive in responding to legal notice strengthens the debtor position in any court action and helping to prevent or unsupported actual claims here, right? So let's get y'all into this, man. The first thing you need to do is you need to actually convey your income of wages and accounts into the living trust, right? So before we get to this, right, man, drop some ones and hit the share button, man, and let me know that y'all with us, man. Let me know that you're with us. Okay? So let's go. Show me. Drop them ones for us. Hit the share button, man. Show some love. We out here showing the love with you guys. So we ask that you just keep it going, keep it flowing. Y'all want more money in the economy, then you need to learn this type of stuff so the money can continue to flow in the economy, right? Let's go. All right, ready? We ready to jump into this thing? Let's do it. I appreciate the participation, people. As always, I appreciate it. All right, so let's go. Conveyance of income, wages, and accounts into the John H. Doe Living Trust. So it says this conveyance agreement is made and entered into on whatever day that you want between John H. Doe, which be yourself, the individual, hereinafter referred to as the grantor, John H. Doe, and trustee of the John H. Doe Living Trust, herein referred to as trustee, under the terms and conditions set forth in the agreement. Whereas grantor has established a trust known as the Living Trust for the purpose of managing and protecting his assets for the benefit of the trust and its beneficiaries. So the grantor desires to convey, transfer, and assign all of his income, wages, and salary and accounts, both existing and future, to the trust for the benefit of the trust and its beneficiaries. All right. And now, therefore, in consideration of the mutual promises and agreements contained herein, the grantor hereby agrees as follows. So we want to transfer the income and wages. The grantor does hereby irrevocably convey, assign, and transfer all rights, title, and interest in personal income and wages from all sources, including but not limited to wages, salary, bonuses, commissions, self-employment earnings, dividends, pensions, and other income into the actual living trust here, family. And effective immediately, all future income, wages shall be property of the trust and shall be deposited directly into the accounts designated by the actual trustee, right? So transfer of bank accounts and other accounts. The grantor hereby conveys, assign, transfer all of his right, titles, and interests in any and all bank accounts, saving accounts, investment accounts, and other financial accounts, whether existing at the time of this conveyance or established in the future, into the John H. Doe Living Trust. The grantor agrees that all such accounts shall be titled in the name of the trust or under the control of the trustee for the benefit of the trust and its beneficiary. So listen, what that means is this. Either it's going to be into the living trust, but remember, you're also being controlled as a trustee. So that also means that now it can still be in your name as a trustee for the benefit of the trust. Don't forget that part, right? Yeah, that's a little glitch for you guys. All right, so power and authority of the actual trustee here. The trustee shall have the full legal authority and control over all income, wages, accounts, and other financial assets conveyed under this agreement. The trustee shall manage, invest, or distribute such assets according to the terms of the trust and for the benefit of the beneficiaries as outlined in the trust instrument, right? So this conveyance is made voluntarily and without consideration other than the benefit derived by the trust and its beneficiaries and to further the goals and objectives of the trust. So now that is based upon the actual consideration, right? So when it comes to no reversion of interest, the grantor expressly waives any right to reclaim ownership, control, or interest in the income, wages, or accounts conveyed into the trust. The transfer is irrevocable and permanent, and conveyed assets shall remain in the trust. Now, here's the thing, though. Just because the grantor don't have the rights don't mean that the beneficiaries don't have the right. Okay? All right? Now, if you guys are looking for us on all platforms, again, guys, we are on In God We Trust Academy. In God We Trust Academy. So just search for us on the different platforms that you are normally on, such like Twitch, Facebook, YouTube, soon Instagram for sure. And what else we on? We're on a few more other things though. So just be in the lookout. In the future, we'll be on iHeartRadio and all kind of stuff. So it's coming. It is coming. All right. So now we on the actual identification of the trustee here. The grantor agrees to identify and hold harmless the trustee from any and all claims, liability, and obligations arising from the income, wages, or accounts that were previously owned by the grantor but are now held by the trust. And then the conveyance agreement shall be governed by and construed in accordance with the law of, if you have a family law, you can use a family law. You can use a religious law. You can say the United States, the laws of the United States of America, or you can put the laws of the Republic of whoever, whatever the case may be, right? You can do it that way as well, all right? And it takes effective on the actual date immediately here. And there's ways you can do this, guys. If I was you, I would backdate it, all right? But, hey, I'm just giving you a little bit extra to know. So now that we got that going, right? We're going to be putting this particular motion in here, and you're going to also take your conveyance and you're going to file that along with it to show that your income and wages that they're trying to garnish in the first place doesn't even belong to you. They're already conveyed to a trust. So that's the thing. And the trust job is to take care of your life. I don't think you guys hear what I'm saying. On TikTok is MNRP6192020. So MNRP6192020. But yeah, go find us. So man, yeah, so I really want you guys to see this, man. So before we get going, you already know, drop some ones, hit the share button, man. Hit the share button, go like and subscribe to us on YouTube. Before I show y'all this document, y'all got to go ahead and subscribe. We got one person subscribe to us on YouTube. So let me see y'all go to In God We Trust Academy and go subscribe to us right quick. Let me know, man. Let me know you're with us. It ain't going to take you nothing but a second. We're going to be right here. We not going anywhere. Don't forget, coming up, do not forget. All right, do not forget coming up, guys, that we have our conference in Huntsville, Alabama. Okay, we have our conference in Huntsville, Alabama. Private administration, private court settlement, lawful money protection, easy to use financial strategies, such as things that we're talking about today as well. All of this is December the 7th, 10 a.m. to 4 p.m. Huntsville, Alabama is $250 in person. If you want to join us on live stream, it's going to be $200. Yes, you will be getting the replay and template backs as well. The deadline is November the 30th, okay? Deadline to register in person is the 4th of December. Okay. So, man, lock in with us, man. And appreciate those of you who just went to YouTube and locked in with us. So appreciate that. All right, man. So let's lock in and let's get in on this right now. Like I say, man, this is a beautiful time for us, right? It's a beautiful time for us. In God We Trust Academy. In God We Trust Academy. Oh, it pops up. It pops up for you. I just seen a couple people already locked in, so I don't know what you put in there, but we're gonna be all right. We're gonna be all right. We're gonna be all right. So look, man, it's all love here though. I really appreciate everybody that's always tuned in with us, man. Before I get ready to show you you guys this document though, man, I have to know. Are you learning something tonight? Y'all learning something tonight? Do you understand what I was just telling you guys about the fact that a third party creditor is just like somebody walking in front of you, paying for your food, getting the receipt, and saying, hey, you owe me. Now, do you owe them? Or did they do that on their own goodwill and it's considered a gift? That's the question. So let me see you guys answer before we open up. What do you consider? Do you think that you should owe a third party creditor, or was it considered a gift because they paid for it? Did they become the surety? Ask yourself that question. So let's see what you guys got to say. What do you guys? Some people say a gift. Oh, gift. It's a gift because they paid for it. Here we go. Here we go. Now, they gave a gift, huh? Yeah, y'all didn't look at it from this perspective, did you? Because find somewhere on the contract where you told this particular company to pay for it. Think about it. Where in the contract, family? Where is it at? Let us know where in the contract does it say that. Because we don't know. We can't find it. Does it exist? Think about that, man. Does it exist, family? And if it don't exist, then they tripping. They tripping. We didn't ask you to do this for us. Okay? We didn't ask you to do this. So, I mean, you can just imagine the conversation saying,
excuse me. I didn't ask you to pay for this, but since you did, I really do appreciate it. Thank you so much. This has delivered me from sin. And we are very, very thankful for you taking care of our debt today. Deliver us from evil. Thank you, thank you, thank you.
and that is what it becomes, right? Could you just imagine? Like, we just give thanks to you. We give thanks to you so much today for taking care of this for us. Thank you. Right? So let's jump in, guys. Let's jump in, man. I appreciate you guys' participation. Let's go, let's go, let's go. So let's act like we dealing with Midland, because Midland be coming for people a lot. They'll just pop up, and Midland is one of the ones that'll take you all the way to the box because they know they so used to dealing with people who don't know. So today, we're going to make sure some people know so they ain't got to be dealt with by Midland. All right, so let's go. So here we go. Motion to dismiss for lack of standing and failure to provide sufficient proof of debt ownership. So comes now John H. Doe. John H. Doe, defendant in the above captioned case by and through undersigned counsel, and respectfully moves this court to dismiss the plaintiff action against him for lack of standing, insufficient of proof of debt ownership, and failure to name the correct party with authority to enforce the debt. In support thereof, the defendant states as follows, right? The defendant correct name is John H. Doe. Now, the reason why this part is in there because I actually just did something like this for one of my people, and they had their name totally wrong. Like, it wasn't their name there. So if you have a name like someone in your family or whatever the case may be, and it's not you and they spelled it wrong or whatever the case may be, this is your right to remedy as well. So rather than any other variation, and plaintiff has failed to provide documentation linking the alleged debt to the correct party with absolute clarity. This discrepancy introduces procedural deficiencies and a potential case of mistaken identity. Lack of standing due to absence of original note. Plaintiff has not produced the original promissory note related to this alleged debt. Only the holder in due course has the authority to enforce an instrument, and the original note serves as prima facie evidence of such actual authority, right? So under UCC 3-301, only the holder in due course, in other words, the party in possession of the original note, may enforce the instrument. Producing a copy is insufficient to establish the actual standing here. So JP Morgan Chase Bank NA versus Mantle, and it was denied. In this case, the court ruled that a mortgage servicer must prove it is the holder of the original note to establish standing for foreclosure. The court emphasized the importance of the original document as a necessary evidence for enforcing debt claims, right? Because that is part of the practice of debt collecting, right? They have to follow the actual Truth in Lending Act as well, right? And they need to make sure that they show when it comes down and receiving these actual things on assignment, right? And when they receive these things on assignment, it's different. It's actual different because they still like the holder. Just because you was assigned something don't mean you're still the original holder of it. And you have to be the holder because the assignment comes with the transfer of the actual material, such as the debt notes, etc., right? That's the thing. It comes with it, right? It comes with it, okay? So, in the Massachusetts Supreme Court Judicial Court held that a party attempting to enforce a debt must demonstrate a clear and documented ownership of the note, thereby confirming the necessity of the original note to establish standing. So, given the preceding above, the plaintiff's failure to produce the original note is grounds for dismissal, as no enforceable claim exists without prima facie evidence required to establish standing. So failure to prove the debt, right? So plaintiff has not provided sufficient documentation proving its lawful ownership of the alleged debt, including an unbroken chain of title from the original lender to the current holder, right? So we got to see that. Requirement of chain of title. So the Dutch Bank versus Lichtenfels, I guess that's the name. But the Ohio Court of Appeals held that a party seeking to enforce a debt must demonstrate a complete and unbroken chain of title. So the court ruled that each assignment in the chain must be clearly documented to validate ownership and prevent wrongful claims. So Carpenter versus Longen, right? 1873, the U.S. Supreme Court confirmed that enforcement of a mortgage or promissory note requires an unbroken chain of title to the actual original creditor. The defendant demands the plaintiff provide a complete accounting ledger of the debt, including all relevant documentation of its sale, transfer, or assignment. Without this, plaintiff cannot establish a lawful ownership or an enforceable claim here, right? So, lack of proof of consideration. Plaintiff has not proven that it or its predecessors extended credit or funds directly to the defendant. Consideration is a fundamental element in the formation of any enforceable contract. They also need to prove that they gave you the funds and then that it wasn't created upon you or funding a financial asset and that it literally was considered exchange, right? Or we can say an actual medium of investment as well, right? So Mortgage Electric Registration System, Inc. versus the Saunders, right? So the Maine Supreme Judicial Court held that an entity seeking to enforce a debt must show it and acted as the lender or provided value in the original transaction. This aligns with common contract principle requiring the lender to demonstrate consideration. So really a third party has to show how we have caused it harm. Can you show us in the books where you gave us something and then we turn around and caused you harm? Like we didn't pay or so? You got to show that to us. Because it can't just be out of your own goodwill that you pay for something. Like, you got to think about it, guys. It's no difference than all the stuff that you buy your children just to find out when you go to court and you be like, well, I've been taking care of my child. Look at all these receipts I got. Oh, well, those were gifts. What? Yeah, it's the same thing. We get to say the same thing here, buddy. That's a gift. You donated that. That was at your own goodwill. You just thought to be a good, great old citizen of the United States, huh? Right? So with that being said, let me get on about your way, buddy. You have a nice day. So unless you can show us some type of contract, we don't know what you're talking about, right? So plaintiff attorney has not shown proof of delegation of authority to act on behalf of Midland. In this case, an attorney must demonstrate authorization, especially in debt enforcement actions, to ensure the legitimacy of their representation. So guess what? Also, an attorney, if the attorney is there to collect a debt on behalf of somebody, he got to be licensed to be a debt collector too. You can't be out here trying to practice anything without some form of license. So, did the firm receive something from the whatever state to be licensed to practice collecting debt as a corporation? That's a big question too we got to ask, because they got to show proof of authority. So let me see it. Let me see it. Let me see it. You know what I'm saying? Pull your folder out, man. Let me see it. Let me see it. Let me see that. Let me see them licenses. Let me know let me know the state gave you authority to practice debt collecting within the state. Let me see it. And they ain't gonna have it. They're not gonna have it, right? Case law and proof of authority, Steele versus Pyers here. In the case, the court emphasized that an attorney must present documentation showing they are authorized to act on behalf of the client, particularly in debt enforcement. Failure to do so can render the action procedurally and deficient and subject to dismissal. Defendant demands that the plaintiff counsel provide proof of delegation of authority to confirm their capacity to pursue their action legitimately. Now, prima facie evidence requirement. Now, this is really what needs to happen. Okay? All right, so watch this. The burden to establish a prima facie case rests on the plaintiff, including producing the original note, proving a valid chain of title, demonstrating consideration, and showing valid delegation of authority. Without these elements, plaintiff lacks claim the evidentiary foundation required by law. Again, guys, they have to show that they have the note. 2, they got to prove the chain of title, that it was transferred or assigned to them. Then they got to also demonstrate consideration, which means they gave you some money. Show me that you put something in my account. Let me see it. How did those funds get to me from you? We need to see, because otherwise I appreciate the gift. That was beautiful, man. That was a beautiful gesture, a very kind gesture. Do you do this often? I mean, hey, I could get a lot of debt sent to you if it's going to be you the one that's going to do this for me. Now, I've never had a friend like this. I would love to keep a friend like this. See what I'm saying? I would love to keep a beautiful friend like this. You're amazing. Yeah, let me know if I can just call y'all and send that to you. I think we can work out something, right? Since you like to do that type of stuff, man, my light bill, they might want to transfer that too. Whoever. But we need to see prima facie evidence, right? So what is the relief requested here, guys? We want to dismiss the garnishment action with prejudice for lack of standing and failure to establish sufficient proof of debt ownership in order the plaintiff to provide full validation of the debt, including the original promissory note and documented proof of all assignment to transfer should this action be refiled. It's done. And you also file your conveyance of your wages. So that's just to let them know that they ain't getting shit no way. Hey, you're not getting nothing here. We ain't got nothing for you. You know what I'm saying? We don't got nothing for you. And if we ain't got nothing for you, it's all with. I can't help you, buddy. We can't help you, man. So I need everybody to understand that part. Like, it's nothing they can do. Everything is all in our power. I hope what you have heard today has really helped you guys because I don't think we think about stuff. You wouldn't let nobody like this play with you in the streets. Think about that. You ain't finna let nobody in the streets play with you like this. Pull up to your house talking about, oh, I paid, you owed so and such, so I paid for it. So now I'm here to tell you, you owe me with interest. What? I appreciate it, but hey, I ain't asked you to do that. And that's all we gonna say. I don't owe you a damn thing. You know what I'm saying? I can handle my own troubles, bro. I pay for it when I get ready. What make you think you get to come up here and say and do this and come tell me I gotta pay something, y'all? Like, man, look. And then they come and threaten to take something from you too. Oh man. Think about that. Are you gonna let somebody come to your house and threaten to take something from you as well? No, 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 no. We cannot do that. We cannot do that, guys. I don't think we can do it. I don't think we can manage that. Could y'all manage that, man? Drop some ones if you learn something tonight, man. Drop some ones if you learn something tonight. How many of y'all learned something tonight? How many of you learned something tonight? Let us know if you learned something. Because I don't think they learning out here. But y'all learning, right? Because that's all that matters. If y'all learning, then we is in the game tonight. We is in the game tonight. And that's what matters the most. So what I will and say to you guys is I appreciate you guys for the night, man. All I ask you guys is continue to follow us. In God We Trust, Facebook as well. Also follow me on Facebook, Eric Ingram Bay. That's where I'll be doing the lives for the next 60 days on here because I have to. Because Facebook got a little restriction on us, not wanting to let us do it for 60 days. So you know how that goes. We got to follow the rules. But on that, man, we're gonna keep on making this happen, and I want you guys to continue to rock with us, and just love. Continue to share. Don't forget Mondays and Wednesdays, family. Mondays and Wednesdays. All right. Mondays and Wednesdays, we will be conducting ourselves with with work sessions, man. Work session season 5 is here. For those of you that don't know what work session season 5 is, man, this is a beautiful place to be. It's like what you've seen today, but we do a whole lot of other different stuff. Man. And again, it's always beautiful to be able to rock with y'all, man. Work session is where we come in and it's free. Mondays, Wednesdays. Mondays at 10 p.m. Central Time. Wednesdays at we at 6. We at 6. Yes, we are. So don't forget, we are ready for you guys to just lock in, man. Because I know I am. I can't wait to meet a lot of y'all in person and at the conference as well. And just other things that we're going to be having going on, like I say. So it's just all been amazing. I've met so many people on this journey. And let's do it. Don't forget, guys, also, for those of you that are interested into the getting this trust set up, I also do one-on-one trust setups as well. You can go to our website, ingodwetrustacademy.com. You will also see all of our things on there as well, so that you guys, if you're interested in anything on there. So just know we are doing trust setup for you guys to help you fully set up your whole entire trust. And not just fully set it up, we're going to make sure that you truly understand everything about the trust, which is why we give you the In God We Trust conference for free. and it comes with all of the templates. It's about 40 templates in there, but about roughly a 5 to 6 hour class that goes over every single document. So you can just take your time with those things, and you'll know exactly what to do and what you actually have. But it's going to be you to do the due diligence to actually learn that, to continue to control that, and run that with your family as well, man. But do not forget Mondays, work sessions, Wednesdays. You don't want to miss it. And if you miss it, man, I don't know what to tell you. I don't know what to tell you, man, because you ain't going to beat us. You can meet us, but you ain't going to beat us. So anybody got any questions, man? We could talk a little bit. Let me see what y'all got. Y'all got any questions right now? Let's talk about it. Because work session season 5 is coming. Y'all got any questions? Let me see what y'all saying in the chat. What y'all saying? Gonna answer a few for y'all. How do you set up the executive office through the post office? Man, if you want to go through all that, you can do it. It's easy. Go to scribe.com and look it up. It'll tell you. I don't really want to explain all of that, but you don't got to go through all that, bro. At all. At all. You do know that an address is considered to be intangible property, right? I just want you guys to know that an address is intangible property, and based upon who's in control of it has the rights and interests in possession of it. So let's be clear on that. I don't think a lot of people know what they be saying. They just be doing something because it was heard of or spoken on or said something, but you don't got to go through all that. How I get access to the Google Drive. I don't know who Google Drive you finna get access to, but it ain't mine. I don't know who Google Drive you trying to get to, but it ain't mine. How do I put my grandparents' house in reverse mortgage in my trust? Well, you have to get your grandmother and them to give their interest through a quitclaim deed to you to be able to do that. That's what you got to do. That's what you got to do. All right. Last session about the letter to send to the credit bureau. See, that ain't a question, bro. That's like a statement. You got to like really state it better than what you're doing. It's not going to work that way. Anybody with a question? Some of y'all questions might know how long it take to set up a trust as quick as you do. I just set up. It don't take long to set up a trust. A trust is you give somebody $1 and you tell them to hold it for somebody for a certain amount of time, and you make sure that you keep it for safekeeping. Boom, we just set up a trust. I was the grantor, you're the trustee, and you're holding it for the beneficiary. That's a trust. It's a trust every day. It's a trust with you going into a grocery store or a restaurant, saying that they're going to cook the food or wherever, deliver everything to you the right way. And it's also entrusted that once you receive the food, you're going to pay for the food, right? That's just, it's simple. Very, very simple method. With the debt collection authority for the attorney, what if they say they're using the company's authority? They got to show proof, though. You can't say or nothing. See, when it comes to corporations, the only way corporations can talk is through papers. Like, they have to have meetings and things like that. That's how that happens, right? That's how that happens. All right? So this is how you purchase all the other classes and stuff that you got. So that'll help you out. All right, so for judgments, we just have to file an appeal, then file this motion, or would this be the appeal? You would have to formulate it into appeal, but you got the right to do certain things. You could do an injunction, all kind of stuff. Totally up to you. Anybody else? Anybody else? What y'all got? What y'all got? I filed a notice of liability today for garnishment. The clerk and the lawyer was shook. If they ignore it, do I go ahead and counterclaim because I have a fee schedule as well? You filed a notice of liability. Depends on what the notice of liability says. Can I get myself? I'm trying to help my fam. Can get myself? Okay, I don't know what you're saying. Can get myself. Trying to help my fam. Okay, well, you got to explain that a little bit more. Is it a 1099-B that I sent to the IRS to claim my time and energy? That's not related to the subject we're talking on today. 18. Dun, dun, dun. Come on. Any more questions before we get out of here? Hope you guys appreciated tonight. I was just trying to see if you guys had any more questions. My people are afraid to do this. I can get myself. I'm trying to help my fam. No, you can't do it without them giving you the interest to the trust. So if they ain't gonna do it, it ain't nothing you can do at all. Help formulate your suits. How do you feel about the University of TikTok? I don't know. Never heard of it. Tell me more about University of TikTok. What is the University of TikTok? What is the University of TikTok? Explain that to me. Never heard of it. No, you can, but you can do something with the 1099 when it comes to the bank based upon all of the cash deposits that you are making. Hey, I know how it go, bro. People are stuck in certain ways, so you can't really just pressure it on nobody. You have to let everybody do what they do, and you just got to go out. And I have to check it out. I'm not going to say your name because it's just weird to say that, but I'll check out the TikTok knowledge of the TikTok University. Peace. Can you use that document you read in the court of equity? Depends on what you're doing. It depends on what you're doing. That's what the matter is. Like, I can answer questions for y'all. Y'all got to be a little bit more specific. What's going on in the court of equity? Because I can't just say, hey, you can use this document, but you got a total different situation going on. So I can't really say that. When setting up the trust on the one-on-one, we getting from A to Z to move accordingly in private, correct? Let me explain this to you. When we set up the trust for you, what I do is this. Like I said, I got a whole conference for 5 to 6 hours that you can sit down that's going to explain every single document that you have, right? Every last one of them, okay? So, and it's going to tell you what to do or how to do or whatever with those particular documents. It's totally up your options, right? And we're going to sit down and do your declaration of trust together. That's really the 101. It's literally making sure the declaration of trust. Then after that, we'll do all the conveyance and everything like that of your property. Make sure that the certificated security conveyances is all done. If you got death certificates and all of that, we'll make sure all of that's conveyed, cars, whatever. We're going to do all of that. And then we'll give you your product and you make sure everything's great. And the rest is going to be on you because I'm giving you a free conference with everything in it to tell you how to do it. So, I mean, it's there for you to do. And then what I've been coming across is some people is lazy as shit because you have it and then you'll be like, I got to ask you a question. And the truth is, it's like, that was the purpose of me giving you the actual conference for you to see it for yourself, and you can pause it, and then you can rewind it, because that is me speaking, and I'm the one telling you. So the same question you want to ask me personally, you can just sit there and watch it. It's for you and your children to have it for the rest of your life, whatever you may want to do with it. But to constantly, nag at me about it is crazy. Crazy, crazy, crazy. So that is what people be running into. Let's see. Did I answer what? What question did y'all have? What was I supposed to be answering? Peaceful in God We Trust Conference. When you send off your 3 bonds of BCs, it's just those, but can you send a master filing BC? If you want to, you can send whatever you want to notify anybody on whatever you want. If you feel like that's what you want to do, you can do it. It's not going to hurt. Do you have to file the trust? File the trust where? See, you can't. You let that so vague. You don't have to do anything with the trust if you don't want to. I just said the executive office at the post office. I actually did give an answer for it. Like I said, if you want to do it, but it ain't necessary. You don't have to do any of that. I don't think you guys get it when it comes to addresses. Well, they're military. No, what you have to understand is they belong to the actual people, and the people are the one that is in control of them for business purposes. That was the purpose it was even created in the way that it's created now, because it is for the business purposes to send out particular mail, etc., for the individuals that you're actually dealing with. There's no need to do it. It's nothing special about it. It ain't going to make your mail less special or greater. It's just more work for you guys to have to do. I know somebody that, I get up and I travel to the mailman every couple of days. Oh, they travel to the post office. Okay. Your bill is still a bill. You just added some extra gas and some extra time out your day when they was delivering it to you anyway. You know what I'm saying? That's the thing. I don't get frustrated. I'm just saying it's just stupid. Like it's no means to it. And I don't talk about stuff it's just stupid. You changed it for what? Like, see, and y'all gotta stop thinking like this. Like y'all let people tell y'all anything. Y'all let them tell you that, if you do this, it takes your right away. There's nothing that the state can do or give you that can take your right away. It violates the Constitution. The Constitution gave authority to implement things that is in harmony with the Constitution, not that's in conflict of interest with the Constitution. And when y'all think like that, that kills it. There's nothing that is making you guys subjective. You know why? And you got to start thinking like this. Who controls you right now? Nobody. There's no earthly authority here that is sovereign over you. Because if it was, you wouldn't be in control of your thoughts. You wouldn't be in control of your decisions and how you move. It don't exist, and y'all got to stop thinking like that. It don't. You keep thinking it does, and it don't. It don't mean a thing. You see what I'm saying? Yeah, I think, okay, it's just like I said, they gave the police immunities. With Trump finna get a police, they already got immunities as long as they're acting according to the Constitution. The immunities already exist. They already exist. What y'all missing is the part where you supposed to understand that you have a right in protecting that. And if you can't assert your right, that's just like if somebody slapped you and you don't know you've been slapped, then you don't know you've been hurt. Same situation, right? Same situation. I have a foreign address that is connected with my trust. It's a 9-8 number as well. You can have all that, but if you can't express your trust, if you can't protect it, if you don't know what to do, if you don't know how to operate in business, if you don't know how to actually sign a particular, to endorse contracts in a certain type of way, to reserve your, if you don't know this, I don't care what type of trust y'all be having, man. And I'm just saying that because, again, people be saying anything. They'll say, oh, yeah, okay. I know a lot of people with a lot of stuff. And no offense to you, I'm just saying, people say that so much. And they have, oh, I got this, I got that, I got this. Okay, well, you got it all. You pay for it all. You know what to do with it. And that's where this happens, right? That's where this happens all the time. We get crickets because they don't know what to do with it. Right? And that means that you're not able to be the trustee. And what that means is now a trust is the trust has been abandoned. That's like the ship was abandoned. So now it's like finders, keepers, losers, sweepers. They're able to find, and now they're able to operate a trust to fulfill it. And here's the thing. Anybody can come and be the trustee as long as they fulfill the trust. So it's no difference than all of us that had a chance to come down here and fulfill the law. But guess what? We wasn't perfect enough to do it. So there was only one who could come fulfill that trust. And they came and fulfilled the law. Man, and we were bought with a price. Beautiful. Beautiful, beautiful, beautiful. Which is why we will always be free. Which is why we can never be held to the debt of man's society. Ever. It'll never supersede the obligations that we owe to God. Right? So that's real. That is absolutely real. Man, I hope y'all enjoyed tonight. It's been beautiful, man. I appreciate everything with you guys. Make sure y'all follow us, man. We'll probably be back on here tomorrow with another casting for you guys. I don't know what we're going to talk about, man. Y'all can kind of hit me up, send me some messages or whatever, and let me know what you guys kind of into or want to talk about. I ain't going to get into too much of the taxations and stuff like that on here because, yeah, dealing with a lot of that, I would rather teach you guys how to show you how to do other stuff first because some of y'all get lost in the sauce trying to chase the money. Can you speak on P.O. Box addresses for the trust? What about it? It's just the address for the trust that now the trust has and will be in control over. And since it is control over, you paid it, you got all rights and interest to use it. You can get anything sent to it. And it don't mean anything. It's an address, bro. It's just the address, y'all. It doesn't, for business purposes, it don't do anything else. Nothing. You know? What's the difference between a mortgage note versus a promissory note? Well, a promissory note could just be a promise to pay some amount of money with no secured interest. A mortgage note is going to have to deal with a secured interest known as a house or some form of actual land. That's the difference because it comes with a deed and title. To where the actual promissory note, it could just be a note based upon a certain amount of money with no secured interest in it, you know, kind of like credit cards. Then you got secured credit cards, which actually means there's a secured interest because you gave something to be held as security to receive those funds. So just being real with y'all, man. But it's all love, man. I appreciate y'all. Nah, I sound sleepy. Nah, I ain't nowhere near sleepy at all, man. I've been sleeping for the past day and a half. Slept all day yesterday for about 10 hours. And all this AM, all this rising, I slept. Man, I'm going to tell y'all, man, the only way you get to receive something free from me, you got to be in work sessions. Get in work sessions. If you get in work sessions, well, the thing about it in MNRP, and this is how you join work sessions. But the thing about it in MNRP is this, yo. Everybody is already a trustee for their trust. So you speak on behalf of your trust yourself. The only way we as MNRP would step in is if you become incompetent in a situation dealing with the trust. And that's the only way, or you're very incapable of dealing with the trust yourself. Other than that, it's you operating your trust. The people are the trustee as well. So absolutely. Make sure y'all join, man. This is free. So I don't want to hear no excuses. This is free. Free. Join. Work Sessions Season 5. Mondays at 11 a.m. Central Time. Wednesdays at 6 p.m. Central Time. And if you are a new attendee, send an email to admin@godwetrustacademy.org and a Google group invite will be sent. Please accept the invite so that you may receive the link to class. You must sign up under a Gmail account. Please do. It will make it very easy, and you can be a part of the group. That any form of chats that be going on in there as well. And not only that, you will also be able to receive stuff that we give out for free or anything like that. And you never know when that might happen. So if you're not in there, but somebody has given you the link and you haven't properly signed up, you might want to do this. So if anything you guys are going to make up, if you want to help somebody, properly show them the way to sign up. Or you can tell them just to be here on the social media site. But the best way to receive the templates and stuff like that I do give out for free at certain times, you might want to be in class. And it's always best to be a member. You can actually pay $100 for the gold option. And every month you will receive all recordings and templates for that month. So that's how that works. Or you can pay individually for whatever particular class you want. As I know some people be in a hurry for something. So I know how that is too. But again, appreciate you guys, man. And it's been nothing but a beautiful night hanging here with y'all. Y'all have a great one. We don't have to re-register with the new admin email, right? No, because you already been shifted over. Only thing you need to do is start accepting those other emails coming from In God We Trust Academy. Yep. That's what you need to do. So start accepting those, because if you already been in, you already been transferred over. You guys are just not accepting the emails. So you need to. And make sure you put a star beside us so that you'll always receive something. If not, always check out spam. Check your spam. Check your spam as well, man. So we about to vibe out one more time with y'all, and we about to get up out of here, man. You know, how many say they gonna ride with us? Yeah. We just want to know, is y'all gonna ride with us? That's all I want to know. Is y'all riding with In God We Trust Academy, man? That's what we want to know. Y'all riding with us? You feel me? You feel me? Where they at now? We want to know. Drop some ones if you ride with In God We Trust Academy. Hey. What we doing? So I hit the ground running. They hate. But I swear I'ma keep it G. No code on it. Can't fuck with me. I'm not a real nigga. I'm just more in the streets. Hey. I'm not a real nigga. Just a street girl. You don't love
love me, you just here for the peace.
So why you trying to take my heart from me?
My heart
Cold.
Yeah, you at the goal.
Hey.
You wasn't with the goal.
So tell me what you here for.
All my people rose gold. LIP for life and
Everything that I earned.
And I got it on my stripes.
You feel me?
If you love me, would you cry for me?
Would you?
Yeah. If you love me,
I just want to know. Because we here, man. We not going nowhere, y'all. They been trying to get rid of us for a long time.
Some people, they done told me it's forever. Yeah.
But they ain't right.
Hey, they ride, they
Hey, I remember they said MNRP wasn't going to last 2 years. We on year 4. Working on 5. Hey, it is so much love out here, baby. You feel me? We still here. Can't get rid of us, man. Can't change what God got. Cause they ain't right. Yeah, we on Twitch too, brother. Yeah, man. Appreciate you guys, man. Y'all have a great and beautiful, and we are out of here.